A very good evening to you, ladies and gentlemen. I am excited to welcome you to the 143rd BASL webinar and the 22nd episode of the Professional, Personal and Career Development webinar series held in English, organized by the BASL Professional and Career Development of Women Lawyers Committee, supported by the Seminars Committee of the BASL 2021-2022. On the topic of Initial Consultation Lawyer-Client Interviews. This webinar series is conducted in the Zoom platform, and for those who have been unable to register on Zoom can also join by watching the live stream on the BASL YouTube channel. We would like to thank the Professional and Career Development of Women Lawyers Committee of the BASL, Chairman of the committee, Ms. Indika Nagaratna Kottagoda, Co-Chairperson of the committee, Ms. Nalini Manatunga, Convener, Ms. Aparajita Aryadasa, and the co-conveners, Ms. Umeshika Dalpadatu and Ms. Vindika Subasingha. Also, I would like to take this opportunity to thank the President of the BASL, Mr. Salia Piris, President's Council, and the other members of the Management Committee of the BASL for all the support and the guidance given to us in organizing this webinar series. Today's topic is Initial Consultation, Lawyer-Client Interviews, and joining us today, we have the distinguished panel of experts ready to enlighten us and to share their knowledge and expertise they have in on this topic. I now take this opportunity to introduce the esteemed panel and the moderator for the day. Firstly, I would like to introduce Mr. Anura Maddegoda, President's Counsel. Mr. Anura Maddegoda, President's Counsel, has more than 39 years of active legal practice at the bar. He served as a senior state counsel in the Department of the Attorney General and as a prosecuting counsel at the United Nations International Criminal Tribunal in Hague, the Netherlands. Mr. Maddegoda, President's Counsel, has been actively involved in the activities of the Bar Association, and presently he is the Deputy President. He has served the Executive Committee during the stewardship of Mr. Shibli Aziz, President's Counsel, and Mr. Upul Jayasuriya. He has also been the chair of several committees of the association, including the Public Interest Litigation Committee, Continuing Legal Education Committee, Police Bar Relations Committee, and Overseas Relations Committee, and he is presently engaged in private legal practice. Secondly, I would like to introduce Ms. Nalini Jayatilaka, Attorney at Law. She has joined the bar in 1990 and has been in practice for 31 years as a lawyer. Ms. Jayatilaka is a professional counselor with postgraduate studies completed in the University of Colombo. She has an active legal practice in labor tribunals, magistrate courts, high courts, court of appeal, and in the Supreme Court. And Ms. Jayatilaka has also made representations for complainants in domestic inquiries in Australia and in Canada. Our next speaker for the day is Mr. Sanjay Kodituakku, Attorney at Law. Mr. Kodituakku joined the bar in 2001 and has been in practice for 20 years. In the year of 2002, Mr. Kodituakku was appointed as a state counsel in the Department of Attorney General, whose expertise was in civil law, served in many areas in Sri Lanka, such as Anuradhapura, Puttalam, Galle, Balapitiya, and Alpitiya, and he was promoted as a senior state counsel in the year of 2011. Mr. Kodituakku retired from the Department of Attorney General in the year of 2014 and continues his private practice in the Southern Province and in the Apex Courts. Mr. Kodituakku also authored the two books named Selected Essays on Civil Procedure Code of Sri Lanka and Idam Sanvardhana Ajnapanatha Pilibandha Satahan Keepayak. He has also contributed as a resource person for many seminars organized by the BASL. And the moderator for the day is Mr. Chamika Guruge, Attorney at Law. He holds a Bachelor's of Law degree from the University of London, and he is currently reading for his LLM from the University of Cardiff. Members joining this session by Zoom may send their questions through the Q&A chat box and to reach the moderator. And I will now hand over the proceedings to the moderator. Over to you, Mr. Gurgit.
Thank you for the lovely introduction, Pasiduni. Good evening, ladies and gentlemen, and good evening to the distinguished panelists. Today's topic for this discussion is the initial consultation in lawyer-client interviews. The legal interviewing is not just about obtaining information. It helps establish an effective relationship with your client. Asking the right question is crucial for building a successful client-attorney relationship. As a lawyer, you need to identify the client's problem and discuss his needs before taking the next steps. If you rush through the initial interview, you might miss out on important facts or lose your potential clients. On the other hand, an effective interview would allow you to collect pertinent data of the issue at hand. Interviewing clients is a skill that improves with practice and experience. No doubt, we as lawyers continue to learn that throughout in our practice. Although interviewing skills are critical to a lawyer's success, few are ever trained how to do it. Therefore, the main objective of today's session is to give you an insight as to the initial consultation of lawyers' client interviews. Therefore, we have divided this session into three main areas. At first, our distinguished panelist, President's Counsel, Mr. Andra Mathigoda, will speak about the importance of initial consultation in the perspective of a criminal practitioner. He will be followed by Mr. Sanjay Kodituakku, Attorney at Law, who will speak in the view of a civil practitioner. And finally, Mrs. Nalini Jayatilaka, Attorney at Law, will speak about the role of an instructing attorney in an initial interview with a client. At this point, I would like to invite you, the audience, to submit your questions in the Q&A box that you wish to ask from our eminent panelists. And with that note, I would like to invite our first panelist this evening, President's Counsel, Mr. Andra Mathigoda, who has a vast majority of experience in both national and international level in dealing with various clients, to elaborate on the importance of having an initial consultation with the client, and more particularly, how to treat a client, as well as what are the rules and ethical standards that we should follow, with special reference to criminal practice, both in original and appellate jurisdictions. Good evening, sir, and it's over to you. So you are on my mute.
Sorry. Good evening, Shamika. I think I've unmuted myself now. And thank you very much for all those kind words, Shamika and Pasundini, in the introduction. So, I mean, if I may straight get on to the topic of the interview of the webinar today, that is the initial consultation and the relationship between lawyer and client. Now, in this respect, I must confess that we as lawyers have we enjoy a very privileged position, and I will be speaking to the audience today from the perspective of both my experience, both in the Attorney General's Department, where my client was the government of Sri Lanka, then also from the perspective of a lawyer in private practice, and also as a lawyer who's practiced in the international arena. So with that experience and with those perspectives, let me tell you that it is, as far as the initial interview between lawyer and client is concerned, because we enjoy a very privileged position, it is our duty as lawyers to ensure that we assist the court in the administration of justice. That is our foremost, our fundamental duty is to assist the court in the administration of justice. The process of administrative justice is a multi-partite process where there are either two or more parties and the proceedings are presided over by a judge who, for all intents and purposes, will be the umpire. We will argue our respective cases, and using cricket and cricketing parlance, he is the umpire of the match that is played within the precincts of the courtroom. We as lawyers will always obey the rules of conduct, rules of engagement, the rules of the game, which are contained in the laws, which are the Civil Procedure Code, the Criminal Procedure Code, the Evidence Ordinance, and so on and so forth. At the same time, as lawyers, we will also obey the decision of the umpire. We will, in the course of our proceedings, we will be raising objections, we'll make submissions, but at the same time, finally, we will bow to the decision of the umpire. Umpire's decision is final and conclusive, and then thereafter, if you disagree with the umpire's decision, there is what is called the appellate process, or in the cricketing parlance, if I may use another phrase from the cricketing parlance, we have a decision review system, the DRS. DRS here is in the appellate court. So in that process, as I said before, we have a foremost duty is the court, but at the same time, we have to safeguard the interests of our client. That is what is important. As counsel, as lawyers appearing on behalf of clients, we have to safeguard the interests of our clients. Now, why do we have to safeguard the interests of our client? Because we are representing the client. The client has come to the lawyer because the client believes, or the client has the perception that the lawyer who is trained in the law will know better than him about the matter that is in dispute. It may be a matter in the criminal courts, it may be a matter in the civil courts, or it may be a matter in the appellate courts, or maybe also in quasi-judicial tribunals. So for whatever reason, the client has the perception that as a man or woman trained in the law, that we have a lawyer has a better perception, has a better appreciation of the matter that is at hand. And that is why a client comes to a lawyer to seek his advice. And also we must bear in mind that our client-lawyer relationship is the bread and butter of all lawyers. So at the very outset, we have to, when the client is either will find us today by doing a Google search or recommended by his friends, recommended by other lawyers, recommended by persons who are known to him or her, and they will come to us, and we have to take what is called instructions, where we must, in the first initial interview, take comprehensive instructions from our client. That is what is important. You mind taking instructions, lawyer is required to take written instructions, you may write down all the instructions that are given, the date and time of your initial consultation, who others have participated at the interview or the consultation, the client, your juniors, your apprentices, any other persons who accompanied the client. It's always useful to note the names of the persons who are present at the interview. Then also the duration of the interview. Now, what time the interview commenced? It commenced at 3 o'clock in the afternoon and went out till 4:15 or 3:40, whatever time. Because now, although in Sri Lanka we do not have that practice, in international jurisdictions, or you have clients internationally, they will ask you, because the client will want, when you send them a memo for fees, the client will require to know how many hours of work has been put in on his behalf. We are required to advise the client about of the time, that the date of the interview, time that was taken, the participants during the course of the interview, the junior lawyers who advised you, the paralegals who were with you, junior lawyers who participated, any other experts who have participated in that interview. So all those names must be noted, and it is very useful because at the time you send out the memo for fees, it may so happen that the client may want to know those details. So that is the reason why we must record all those details and have a note for your file. Now, in international jurisdiction also, in the international court, whenever clients, now in the international tribunal that I worked in for a period of 10 years, we had clients from various jurisdictions in the former Yugoslavia, from Bosnia, from Serbia, Croatia, from Slovenia, and most of those persons were non-English speaking clients. So you have to take the instructions in the language of the client, and then we would have an interviewer, an interpreter participating at the interview to translate what is being said by the client. So in that process, I have got used to taking comprehensive notes and making a full record, keeping a full, complete record of the interview. Then also, there are times, particularly in the international jurisdiction, where those matters come into play. The judges would want to know what time the interview was held with the client, where the interview was held. And for that reason, it is always, because you are at the time of trial, 1 year after the interview, or 6 months after the initial interview, you are bound to forget all those details. So it is always in your interest, in the interest of the lawyer, to maintain a record of those events and to take comprehensive instructions. Now, whilst doing that, we must also we must remember that we have to be courteous to our client. Because as I said, our bread and butter is the client. So we must be courteous to our client. You cannot ride roughshod over the client. Be very courteous. And also, we must be diligent in the business that we deal with as far as the client is concerned. We must also ensure that we maintain absolute confidentiality of the matters that the client has discussed with the lawyer. Absolute confidentiality. That's a privileged communication that the client will provide to you. So there is absolute confidentiality. And there are also the diligence aspect of it has to be maintained. As far as lawyer-client privilege is concerned, I take the view that not even the Supreme Court can demand a lawyer to divulge sources of his interview, to divulge confidential matters that have been divulged to the lawyer in the process of the lawyer-client interview. Those are matters which are privileged, and you do not have to even disclose such facts even to the Supreme Court. That is the privileged communication we have, which is also protected by the provisions of the evidence ordinance. So we must bear that in mind. Lawyers must always bear in mind that they enjoy a privileged position. The lawyers will act on instructions that are given. At all times, you have to have instructions to act on behalf of a client. And having those instructions, you have to formulate your legal argument, formulate whatever strategy and your legal argument that you present to court within the four corners of those instructions. A lawyer should always remember that he or she should not act outside instructions that have been given. And those instructions are sacred, so you have to maintain the confidentiality of those instructions. Now, as far as Sri Lanka is concerned, lawyer-client relationships are governed by, we have the rules of the Supreme Court that have been promulgated in order to govern that are applicable to lawyer-client relationships. I am not here. I do not think we will have the time today to go into each one of those rules that bind us. But at the same time, we must also bear in mind that the rules are contained in the Supreme Court conduct of and etiquette for attorneys at law, rules of 1988. Those rules also will also tend to be read in conjunction with the provisions of the Judicate Act, because in the event we act outside or act in breach of those rules, we may open ourselves to disciplinary conduct. So that is also rules related to disciplinary conduct are also contained in the same rules that I just referred to. We must also make sure we remember that we have the Judicate Act, which governs the disciplinary procedures as far as the lawyer-client relationship is concerned. In taking the initial interview with the client, I mean, you must take time with the client. The client must have the confidence that he has come to a lawyer who can advise him, who has the knowledge, the depth of legal knowledge to advise him as to the matter that he is faced with, whatever the matter is. So we must, in order to give him that confidence, the lawyer must take his or her time. Take your time in the interview, because interview cannot be completed or concluded in a matter of a few minutes. And also we charge good fees for the interview, for the initial consultation, if you may call it. So for that reason, the client also hires your services, and the client pays for your services. So upon payment being made, the client is entitled to the best possible advice that the lawyer can give. And we are required to give that as a matter of course. I think we have a duty as lawyers to ensure that we provide the best possible advice to our client. There is also another aspect of the matter that I will deal with. That is, in order to build the effective relationship between lawyer and client, we must also make sure that we have that there is no conflict of interest with the client's cause. There is a general rule, and also which is also contained in the rules of the Supreme Court, that any client who comes to us, we have to accept the brief, unless there is a personal reason why we do not want to accept it. Unless there are personal reasons why you should not do it, it will always be the rules require a lawyer to act in a matter where a litigant seeks his or her services. If there is a conflictual situation, then we are required to recuse ourselves, to excuse ourselves from that matter. Or if there is a matter where we feel for personal reasons, the lawyer is of the view that he should not act in that matter, then that is another instance where you could very politely tell the client, litigant, that you are unable to act in that particular manner. But at the same time, subject to those exceptions, we are required to take on the client's cause, act for the client to the best of our ability, to present the client's case to the court in the most effective and in the most strategic way, to ensure that we provide those legal services within the four corners of the law. We also have to remember that the cardinal rule is that a lawyer is required to assist the court in the administrative justice, acting within the parameters of the client's instructions. We have to assist the court in order to administer justice, because we are all players in that administration process. We are all players in the judicial administration process. But in that process, we provide that service within the four corners of the brief, of the instructions that have been given to us. It is important to maintain confidentiality. It is also important at all times to maintain a very good cordial relationship with the client. That is also a very important factor which lawyers must remember. Because it is when you maintain a cordial relationship with the client, that there is confidence that the litigant has in the lawyer's ability, in the lawyer's skill, in his competence, in the lawyer's knowledge of the law. And that will invariably grow as years go by, as months go by. And you will develop a very healthy relationship with the litigant. The other matter is we must always keep the litigant, our client, informed of all the steps in the case. The client must be advised about what is entailed in the case. The lawyer must be able to make an assessment of the success or otherwise of the matter, to make an assessment of the value of the evidentiary value of the material that is placed before you. And also the lawyer should also remember that we should not give false hopes to the client. We should not give a false hope to the client. We should not, and also we should not accept when there is no case. We should not give false hopes to a client saying, yes, there is a good case and this is a case that can be maintained or that can be won. Those are not good practices that a lawyer should adopt. In order to succeed in the profession, in order to have a successful legal practice, I believe as lawyers, we have to maintain those standards. We have to maintain the highest standards of professional conduct. We must also, in order to win your client's case, or to argue, or to fight for your client's cause, or win your client's case, you must also win over the confidence of the bench. The confidence of the bench is very important. Because if you win over the confidence of the bench, you have 50% of your battle is won. In order to win the confidence of the bench, there is no way that you don't have to fight the bench all the time. The lawyer can be very polite with the bench, whilst at the same time you can put forward your client's cause, or your client's argument can be put forward. Then also we must also remember as lawyers that we have to maintain a very courteous relationship with members of the bar, with our fellow brethren and sisters. Because at the end of the day, we are all members of this noble profession. There is no reason for us to fight in court. I have seen lawyers being very hostile to your opponents. Now that is not necessary. There is no necessity to be hostile or to be antagonistic. I have had counsel, I have been opposed to counsel who are hostile, who are antagonistic. But then that is not required. That is not necessary. You can maintain that courtesy with the bench and the bar. And that also helps you to put forward your client's case and your client's cause in a very effective manner. Then there are a few other matters that I would like to deal with, but I want to know from Charmika how long I will have, because I know I realize
you can take another 5 to 10 minutes, no matter.
Right. I realized that I'm now taking the time of others, which I don't want to do. So now, having gone through the initial interview, as I said, we must keep the client informed of all the progress of the case, or the steps that are to be taken, whether it's a civil matter or a criminal matter, or whether it's a matter in the public law domain, whether it's in the Supreme Court or the Court of Appeal. The client must be advised what happens. What happens when you support the matter in the Court of Appeal or the Supreme Court? And thereafter, what the next stages, the next steps of the case are. In the criminal courts, what happens when the charge is read over to your client, to the accused? And in the civil, in a civil jurisdiction, Sanjay will cover all that area, but in a civil jurisdiction, what happens after summons are issued and the defendant appears in court? So those steps must be explained. The written submissions that you require to file written submissions at some point in time. Before filing the written submissions upon, of course, if you take a preliminary objection, that written submissions may have to be filed on that issue. But before that, before you get to the stage of written submissions at the end of the case, the leading of evidence, the finding of witnesses, So all those matters the client must be advised so that the client knows in advance what steps or what assistance he has to give the lawyer. We must give the client sufficient time of notice of that. The lawyer must not tell that, must not advise the client the day before the case that this is what has to be done on the next day. That is why it is important that if you advise the client of the future progress of the case, the client also will have time to also provide his assistance, provide his support to you, to advise you about the relevant documents are, who the witnesses are. And he will also be able to do all the spade work for you with the assistance of your juniors or with the assistance of your paralegals. So in that way, that will also help to build a healthy and a cordial relationship. So it is and also a client, once you build a healthy relationship, a cordial relationship, and you instill confidence in the client, even if you lose the matter, the client is still satisfied. Client does not go unsatisfied, dissatisfied. Despite the fees that the client has paid, the client knows that the lawyer has given of his best for his cause, has given of his best. So for that reason, the result may not, the outcome, the result of the case may be immaterial if the client is satisfied that his lawyer or her lawyer has done his best for his cause. So that also you must remember, and then you must also have regular interviews with clients before every step of the case, so that the client again is advised and also becomes ready for the case. And then that will also, if you build a healthy relationship, a cordial relationship, that will also, because we find that there are disgruntled litigants who at the end of the process will make a complaint against the lawyer. There are a number of matters that are before the Supreme Court where disgruntled litigants make complaints at the end of the case. The litigant says that the lawyer didn't do this, he did the other thing, he didn't call this witness, he didn't call the other witness, he didn't produce the document. So when you advise the client in advance of all those steps, he is also well advised of how well you have handled the matter. So that is the way to proceed, and that will also prevent clients from proceeding to take proceeding to make complaints leading to disciplinary action against lawyers, disciplinary action either initiated by the Supreme Court or by the Bar Association. So those are also initial matters I need to deal with. I wanted to advise to speak to you about this evening. So with those remarks, I know there are two other speakers. I will also make my comments at the end of it in the Q&A session and thereafter, and also take any questions, leaving room for Sanjay and also leaving room to Nalini to continue with their presentations. Let me at this stage hand over, let Chamika take over, the moderator can take over, and we will proceed from there. Thank you.
Thank you very much, sir, for providing us a valuable insight on today's topic. Also, once again, I would like to remind our viewers to submit their questions in the Q&A box. I would now like to welcome our second panelist this evening, Mr. Sanjay Kodituakku, attorney at law, who is a civil law practitioner in both original and appellate courts. Sir, as we are well aware that civil law is a very vast area, and therefore the identification of the relevant issue is crucial. Also, we have observed that in some instances, some clients want to intervene to a pending action, such as a partition action. At the same time, it is significant to know how to decide the most appropriate forum before commencing the litigation. So I would like you to provide your thoughts and insights on the above issues, and more particularly, the value of having an initial client interview in a civil action and choosing the most appropriate forum for the issue presented, as well as other alternatives that may be available for the client. Sir, it's over to you.
Thank you, Chamika. First of all, I would like to thank the organizers for inviting me to share my views on this very important topic. Because sometimes we talk about various subjects in depth, but sometimes we forget about our basics. So this is one of the most important aspects that one has to consider. And this is one of the first lessons that a junior lawyer should be taught before we go on to the other matters. Therefore, I'm thankful to the organizers for organizing a webinar on this issue and in fact giving us opportunity to share our views. In fact, Mr. Honorable Madhyagoda President's Council was kind enough to give a very good insight to the topic. In fact, that made our task very easy because we'll have to adapt to what he has said, and basically he has laid a very good platform for the webinar. In fact, when I was thinking of my presentation, I wanted to emphasize the importance of the role of an attorney at law in a civil litigation. Now, especially when it comes to civil litigation, as Chamika very correctly pointed out, it's a very vast area. And sometimes to identify the forum where you should go and identifying the proper remedy will not be that easy. Therefore, the role of an attorney at law or a role of a lawyer in a context of that nature is very relevant. In fact, when I was reading on this, I found some interesting paragraphs in His Lordship Justice A.R.B. Amar Singh's book on professional ethics and responsibilities of lawyers, wherein His Lordship has cited from an article in his book. I wish to quote that portion. How it says, "But the ordinary man is incapable. He cannot know the principles of law or the rules guiding the machinery of law administration. He does not know how to formulate his desires with precision and put them into writing. He is ineffective in the presentation of his claims." So this is the problem that a layman has, and this is a problem for which a lawyer should give proper remedy. And further, His Lordship has cited an American judgment of Powell versus Alabama, which has stated like this: the right to be heard would be in many cases of little avail if we did not comprehend the right to be heard by counsel. Even the intelligent and educated layman has small and sometimes no skill in the science of law. So this is the problem. So when now Mr. Madhyagoda and myself were fortunate enough to serve in the Aegis department for quite some time. Now those days, when I was a state counsel and a senior state counsel for some time, we used to receive files from various government departments and various statutory bodies. When an action is instituted, a civil action is instituted against them, they used to come to us with their documents and with the other information. Then when a government department needed, or a government instituted needed the assistance of the Attorney General to institute action, similarly, likewise, they had all the material with them. So as State Counsel, we did not have much difficulty in gathering information because their files are made, basically their files are complete. So, and they had a set of experienced officers as well. Sometimes certain officers used to come to us and say that there had been some similar cases that were pending in various courts, and various judgments too have been delivered in favor of the government. So the duty as a state counsel, member of the official bar, was easier than that of a private counsel in receiving relevant instructions. Now, the Learned President's Council has dealt with obtaining instructions from various clients of various walks of life, such as corporate clients, then international clients, and sometimes I don't think that there are much difficulties in obtaining the proper instructions and proper documentation from them. But when it comes to a rural area, where a man is faced with litigation, and sometimes that man becomes very helpless. That person becomes very helpless. That person comes to us running, sometimes shivering, or sometimes with a lot of emotions. And sometimes I have observed certain clients crying in front of us, saying that that various misdeeds had been done by the opponents. So in such situations, especially in a civil dispute, how are we going to assist them, and how are we going to have their instructions properly? That is the area that I am going to discuss with you. Now, generally, when we come to civil litigation, sometimes clients may come to us seeking to institute action. Now, for instance, the adjoining landowner has encroached a portion of your land. Then you come to see me intending to file action against the adjoining landowner. Sometimes some party may have filed action against you. Then you will have to defend your case, and you will have to consider what remedial steps that you should take. And as Chamika very correctly and very appropriately pointed out, there are certain instances in civil litigation that we will have to intervene in pending actions. So then certain clients would come to see us, and they may seek our assistance in intervening into pending actions. And sometimes there are instances where certain clients come to us with partly heard cases. Sometimes the case may have been drafted by some other counsel. The case may have been handled by some other counsel, but at some point of time, the client forms the opinion that this would not help him. So in that event, sometimes he may think of sometimes changing the counsel with the permission of the instructing attorney, or sometimes they revoke the proxy and they want a fresh instructing attorney and a counsel as well. And then sometimes clients come to us with civil appeal briefs, and those cases we have never done in the original courts. So in these type of situations, this initial consultation plays a very, very crucial role, because without having a proper understanding of the nature of the case, you cannot do anything. Therefore, as Mr. Maddegoda very correctly pointed out, we should devote a lot of time, and we should endeavor to peruse whatever the documents that they bring and whatever the material that they have to ascertain what the real dispute is all about. Now, sometimes, as I told you earlier, not like in the official bar and not like in corporate litigation, these clients may not have the material relevant to their cases. Therefore, it becomes our duty to assist them and ask them to get ready with their documents. Because sometimes I have come across a number of situations where partition actions have been filed against certain clients, and sometimes they come to me, and they used to come to me without anything except for the summons that they have received from the registry of the district court. So in that event, as counsel, we will have a duty to show them the correct path as to what to be done, because most of the clients, except for a few experienced litigants then and there, most of the clients, they don't have the enough experience in litigation. Sometimes certain clients are misled by certain unscrupulous elements, and as a result of which they get into trouble as well. Therefore, in the initial consultation, we will have to go through the material that they are having very carefully, and we'll have to give them the proper advice. And sometimes we may have to advise them. Now, especially in cases where the clients seek our assistance to file action, sometimes we may have to advise them to wait a little longer. Or sometimes we will have to inform them, as Mr. Madhyagoda very correctly stated, that there is no point in going for litigation. And for that, what now I wish to share with you one method that I use generally. Now, sometimes, as Mr. Madhyagoda has pointed out, the clients come to us from various sources. Sometimes instructing attorneys retain us. Sometimes our long-standing clients, they recommend us to be good counsel, and on that information, clients come to see us. Then when they come, we can have a brief discussion with them for about 10 or 15 minutes to understand the basic nature of their grievance. Then thereafter, if they have brought some documents, you can ask them, if they so wish, to leave the documents with you, or at least photocopies, for you to peruse them and to have some better understanding of what they say. Then sometimes the initial consultation will not happen on the very same day when the client comes to you. You will also have to get ready, and you will have to understand what his case is, because sometimes whenever there is a land dispute, they will come and say that it's only a land dispute. But when you look at the issue in depth, then only you will realize what type of a dispute this is. Whether it's a case fit to be go for a partition action, whether it's a case which is fit to be for a reivindicative action or a possessory action, or say definition of boundaries, or whatever it is. Because we have seen a number of cases in various courts, including the Colombo courts, that those cases are filed without clear understanding of the nature of the dispute. Now, because of that, the case may have gone for more than 10 to 15 years, but at the end of the day, nothing will happen, and the client loses the case, and he loses a lot of money as well. So therefore, this initial consultation should take some time, and at the initial consultation, sometimes you may decide to have another set of consultations also. So in that event, you will have to inform the client that it is not the issue that you have brought, but there are certain other matters that we will have to take into account. Therefore, we will have to have another round of a consultation as well. So even when you are defending a case, when you are supposed to file an answer to an already instituted case, you will have to decide on the precise defense that you are taking. And mind you, a civil trial proceeds on issues and not on pleadings. Therefore, whatever the pleadings that you draft should be drafted enabling you to raise relevant issues at the point of trial. Otherwise, you will basically you will lose the case and you will not get the optimum benefit that you are seeking. Then, as Mr. Maddegoda very correctly pointed out, if the instructions given by the client shows that we have a very, very weak case, or we have no case at all, we should not be afraid to inform that to the client. The client should know where he stands. Without a proper understanding of the merits or the nature of his case, he may not be in a position to proceed with the matter. Sometimes he may be ready to spend money. He may be a moneyed client. He may have money. But if, as lawyers, we find that the relevant case is not a very good case, then of course we will have to advise our clients accordingly. Now, even these cases where intervention is sought. Now, sometimes clients come to us seeking interventions. Now, Shamika has mentioned about partition actions. Now, Section 69 of the Partition Action permits a party, whoever the party, to intervene before the judgment. But there also the court has been granted discretion. It is not each and every application for intervention that is permitted. It has to have some merits. There are a number of instances where courts have refused intervention in partition actions, and even the appellate courts have upheld that position of the lower court. Now, even in an ordinary civil case, now we know Section 18 of the Civil Procedure Code is there, and there is some misconception among some of our colleagues that Section 18 of the Civil Procedure Code can be used in any case, and intervention is permitted whether it has merits or not. Sometimes this judgment of Arumugam Kumaraswamy versus Andiri Sappuhami, that has been misused several times, and I'll have to tell you that there is a very recent judgment by late His Lordship Justice Priyantha Jayawardena on this point, that is New Lanka Merchants Private Limited versus Ceylon Bank PLC, wherein His Lordship has set down certain principles, certain guidelines, 10 guidelines with regard to the intervention in a pending civil action. So therefore, when you are advising your client whether to intervene in an action or not, you will have a basic understanding of the relevant law, and you will have to be mindful with the developments of law, because sometimes the previous principles may not be applicable with the subsequent judgments, and without proper understanding of these new developments, sometimes you may not be in a position to advise your client in a fruitful manner. And even now, I have mentioned about these partly heard cases. Sometimes clients come to you when they were not happy with the previous counsel who was handling the case. Sometimes they will come to you with a partly heard case, partly heard brief. Then, of course, you find it extremely difficult, because generally the drafts are not yours. The manner in which the case was handled is not the manner that you have. You generally, do it. So, in that event, you will have to have an extensive consultation with your client and see whether you can undertake a case of this nature. Because just because you have been retained in a case of this nature, sometimes it will not help the client, because sometimes it may be like flogging of a dead horse. Now, I will give you an example that I had in a provincial court. In fact, it was a money lending transaction. It was a case of money lending transaction, and there was a plaintiff and who was claiming a sum of money from the defendant, and it was the position of the plaintiff that the plaintiff had got lent money, some 10 lakhs or something like that, to the defendant, and on the very same day, the defendant at the very same moment, the defendant signed a document and handed it over to the plaintiff. And it was the position of the defendant that no, I did not do that. It was done forcefully. And the defendant admitted that there had been number of previous transactions, but those monies have been settled and there was nothing for the defendant to pay the plaintiff. Now that case came to me little later, but fortunately for me, there were some material witnesses to give evidence in that case. Therefore, I was able to make a breakthrough in the case. Otherwise, I think with the material that was available in the brief, I wouldn't have done anything fruitful to a case of this nature. Therefore, you will have to be very careful, and especially at the consultation stage, you will have to question specifically about the evidence that have been given by the previous witnesses in a part-heard case, and what is the version of our client on that. And if our client has made certain allegations against the opponent, whether those allegations have been put to the witness by way of cross-examination, because I think you all know the judgment of Cinemas Limited versus Soundarajan. There it says that if you do not put the relevant questions, the relevant material facts, material defenses by way of cross-examination to the opposing side, then of course you will be in a bit of a difficulty. So these things we will have to take into consideration when you undertake a partly heard civil case. So those are some of the basic things that I would like to share with you. And at the same time, I fully associate with Mr. Maddegoda, President's Counsel, with regard to the professional ethics aspect. Because as I told earlier, we should have, we as lawyers, we cannot have knowledge of everything in law. That is quite impossible. But we should have the basic knowledge of the basic principles of law. And we should be abreast with the recent developments of them. Now, there are certain instances, certain judgments are delivered by the Supreme Court, and those judgments sometimes overturn the entire jurisprudence of particular areas. I think you are quite aware of certain judgments delivered by the Supreme Court in part with regard to partition actions, and those judgments have created new positions. So those things will have to be with you at your fingertips, because otherwise you will find it extremely difficult in assisting your clients. And as the Learned President's Counsel has stated, you will have to inform them where they stand, and don't mislead them, and don't give them high hopes, and play your game according to the rules. Don't try to get involved in illegal or unethical practices, and have confidentiality of the material that is provided by your clients. I think those are the matters that I wish to emphasize, and I'm very happy to answer whatever the questions that are raised at the Q&A session. Thank you very much.
Thank you, sir, for providing us with your valuable insights. Next, I would like to welcome our final panelist this evening, Mrs. Nalini Jayatilaka, attorney at law, who has a vast experience of working as an instructing attorney for many years. Madam, it is clearly identified that an interview is not the same as a conversation. It has specific purpose. When it comes to an initial interview, the main purpose is to identify the nature of the client's problem. The client will outline the nature of his or her problem, and the effective interviewer will probe for the salient information from that. Therefore, an instructing attorney plays a vital role in identifying the nature of the client's problem. Madam, I would like to hear from you that the importance of having an initial consultation with the client, and more particularly the role of an instructing attorney in an initial interview. Madam, it's over to you. Madam, I think you're on mute. Please.
Sorry.
Okay.
Thank you for this opportunity to share a little bit of my knowledge. Firstly, I would like to tell the young lawyers that at the very first interview with your client, please make sure that you have time to spend with the person. And when the person comes, have a sheet prepared like this. I don't know whether you can see. That's for client's information. Client's information, so that the name, contact number, NIC number, and other information is jotted down. You give the paper to them, then they will write down their occupation, the problem and the issues, and ask them to describe the issue, whatever they are seeking, right? It doesn't have to be a major big explanation. Just in point form, if they write down whether it's a problem at the workplace, or whether it's a problem at home, or whether it's a problem accident, or whatever it is, get the information in writing from them, and always get a photocopy of the ID. Keep that ID, and when you're talking to them, always think about your appearance, your attire, right? And your language. Be kind to them and also respect them. And make sure that they respect you as well, right? And listen to their, whatever they want to say, listen and jot down, take down notes. And also remember, as Mr. Medhukota said, that confidentiality, it's very, very important. Whatever they tell us, it is confidential, and we do not discuss about it with anybody. And also, maybe not at the initial stage, but please get them to get you a Grama Sevaka report regarding their residence, right? And also have a that filling out form information and the NIC copy, put it in a separate file. Always have a file for each person, each client. And keep a CR book. This CR book is for you to maintain all records, which court, the case numbers that you appear, and the next date, and the counsel who appears for the other side, and the instructing attorney's information. And also keep a CR book for your land registry work, okay? And keep 2 diaries. Keep one diary at home, the other diary you take. If by chance you lose a diary, there is the diary at home, which will help you, right? And always keep a notebook as well, and pens in your bag. Don't go anywhere without that notebook and the pen. Also have your visiting card, simple visiting cards with your name, address, and contact telephone numbers. When the client comes, before the client leaves, please make sure that you give that visiting card to that client, because in an emergency, the client needs to contact you, or give that card to somebody, to a family member or anybody like that. And then again, if by chance the client comes to you, the client who comes to you is coming regarding a criminal case, always take down the reference number of the police complaint, and then make sure that you apply for a copy of the statement, but the complaint that they have made at the police station, or the complaint that the other party has made against your client at the police station. And then if you have to participate at an inquiry, police inquiry, make sure that you take notes and also apply for certified copies of the statements and of all people. And then at the initial meeting, if it is actually the person who's coming to you is a victim of abuse, make sure that you go with that client to the Women's and Children's Bureau in the area police station and ensure that the person makes a complaint. Or if the person has injuries, if you can't go, please make sure that somebody goes with that person to the hospital, and also inform the National Child Protection Authority if it is, especially if it's a child. And if it is civil, if it is a civil cases, their civil cases are concerned, please keep copies of the complaints in separate files, and make sure that you obtain affidavits or some statement from the witnesses who have seen that action, right? And then also at the initial stage, this doesn't arise, but subsequently always make sure that you file a motion to make sure that something is of record, so that the judges know that you are not playing the fool, right? Put it on record. And then at the initial stage, when you take down the client's information, make sure that you advise the client, right, about the cost, and make sure that you tell your client that you need to retain a counsel. If you don't appear, if you don't do counseling work, then that you need to retain a counsel. If it's a civil case, a civil lawyer; a criminal case, a criminal lawyer, and then counsel for criminal cases, and then go and meet that counsel with the client. So all that costs money. So make sure that you make the client aware of roughly what the cost is going to be. They have a right to know, right? And then if it is employment, then you have to make sure that if it's a labor tribunal case, you have to make sure that affidavits are taken, documents are prepared, so that you are ready to go before the council and to retain the council and go before the labor tribunals. And then again, you need to prepare and have letters, a letter like this, so that this is just a draft letter where you address it to the police station, police OIC of a particular police station, asking for, applying for certified copies of statement made on whatever day, right? Keep that. And also remember, this is something that we all need to be very conscious about, the proxy forms, right? Keep the proxies on the very first day. If you have to get their signature and the copy of the national NIC. Okay, thank you. I think my time is up.
Thank you, Madam, for your valuable insights. With that, now we will move into the questions and answer session. We have already received a few questions, and once again, I would like to invite our viewers to submit your questions in the Q&A box. Then I will forward them to our panelists, and they will definitely provide very good insights to your questions. The first question that we have is that does a lawyer has a duty as a professional to disclose information about the suspicious method of income of a client to the Financial Intelligence Unit of the central bank, and if it is, how it affects the lawyer-client confidentiality? I think Mr. Madhuguri, you may be the most appropriate person to answer this question.
Chamika, could you repeat that question, please?
Yeah,
does the lawyer have a duty
as a professional to disclose information about the suspicious methods of income of a client to the Financial Intelligence Unit of the central bank, and if it is, how it affects the lawyer-client confidentiality?
My short answer is, if I am asked by the Financial Investigations Unit, I will not disclose any such information which has been given to me in confidence by my client. And my answer is no, that is this confidential privileged communication between me and my client, and I'm not prepared, I'm not bound by law to provide that information to you or to anyone else. As I said, the privileged communication as contained, as protected and envisaged, recognized by the evidence the audience will apply. I have myself refused to do that. And my position has been that not even the court is entitled to ask that as far as my client's information from my client is concerned.
Mr. Kodito, do you have anything to add to that? You're on mute, sir. You're on mute, sir. I think.
Right. Okay. I think what the Learned President's Council has stated is correct, because now when a client comes to us, and when a client gives us various instructions with regard to his financial transactions, that becomes a privileged communication. And except on very exceptional situations, I don't think that we are bound to disclose those privileged communications. Thank you.
Yes, if I may add this, Chamika.
Yes, sir. Sure.
The content of the privileged communication is what is privileged. The content of the communication between client and between lawyer and litigant. The fact that the client came to see you, yes, is nothing wrong. There is nothing wrong in disclosing that information. When did the client come to see you? Right? At what time? Who else came? Those are matters that are, you can disclose. But the content, what is important is the content of that disclosure. Right? Inasmuch if a client comes to a lawyer and confesses that he committed the murder, the lawyer is not required to go to the police and confess and tell the police, here, look here, my client has now confessed to me that he has committed murder. Right? So there is no requirement on the part of the lawyer. The client, the litigant will advise the lawyer as to what happened, the circumstances of the incident. If you take a simple incident of murder, the circumstances in which it happened, that whether it was under provocation, whether there was a sudden fight, whether there was any other circumstance that makes it fall within, to section 297, whatever, right? The circumstances surrounding the event. It is for us as lawyer to make sure that we take those instructions and then we present an argument, a formidable argument to the court. That is what we have to do. So in the same way, a client comes to me with certain information and the financial investigations unit of the central bank is investigating it, or maybe the CID or any other Colombo Fraud Investigations Bureau investigating. The fact that that content is what is protected. Let us say there are instances where the fraud bureau will ask lawyers about certain deeds. Whether somebody came to attest a deed and who it was, all that. So that information you can give. There is no confidential, no sanctity attached to that information. But whatever communication that the litigant gave to you stands privileged, because it is in that confidence that he confides in you. He will confide in the lawyer certain matters which you would not confide in anyone else. Sometimes not even in his spouse. Okay? So that information will remain confidential. You must take it with you to the grave. No one else, nowhere else. Even after the time that you take it, go to the grave, that information must be with you and with you alone. That is my position on that, the question that was directed, Chamika. And I'm sure Sanjay also says that, and I'm sure let's see what Mrs. Jatilake, Nalini Jatilake has to say to it, but those are my views on the matter.
Madam, you have anything to add to that? Do you have anything to add to that position?
No. I agree totally with what the President's Council, Mr. Madhukar, said.
Yes. Thank you, sir, for your valuable explanation, sir. Next question I would like to pose to Madam for you. This is regarding being an instructing attorney. What are the things that we must take into consideration, and what are the steps that you need to follow before retaining a counsel for the case? I may repeat that question. Being an instructing attorney, what are the things that you must take into consideration, and what are the steps that you need to follow before retaining a counsel for the case?
first you have to take into consideration the capacity of your client, whether the person can pay. And then especially when you're in the district court, watch how each counsel conducts himself, right? Then you have generally you have a rough idea of people who are really good at land matters, divorce matters, and then you have a rough idea of people. And then when the need arises, combine the two, the capacity to pay and who should be consulted, retained as counsel.
So Nalini, what you are saying is you should have an assessment of the competence of counsel.
No. What is important
Competence
is,
of the...
it is not only it's not competence exactly. We need to know, the instructing attorney needs to know the capacity of the client for payment.
Yes,
right?
definitely.
And then
Capacity
we
plus
need to
competence.
understand capacity and we need to understand the whom we should retain, whether which counsel you have to choose the appropriate.
Yes. Thank you, madam. Thank you, madam, for the explanation. I would like to pose this question as an open question for all of you. Since you all have different approaches regarding this aspect, I would like to raise this as an open question for you all. And this is that what are the skills and strategies required improving the client interview, and how to develop those skills and conduct an effective client interview? Basically, he's asking whether what are the skills and strategies that we must improve to have a successful client interview.
Take that first. I think in my opening remarks, I dealt with some of them, the skills and what do you say, the skills that are required and traits that are required. You must first, I have to remember that you have to instill confidence in the litigant, confidence of yourself as a person who is competent to handle his or her matter. The litigant comes to you with an issue, whatever the issue is. He's been, as we discussed earlier, has been referred to you by friends, by lawyers, by instructing attorneys. He has seen you appear in court for whatever reason. So then you have to develop that the litigant has some confidence, because the litigant also knows you are supposed to be knowledgeable. You are a trained lawyer, trained in the legal profession, trained in the law, and for that reason. So then you have to make sure that you build on that confidence that you have. So you have to have an effective relationship with the client. There must be that interaction between lawyer and litigant, that effective interaction. You must, another important aspect is try to be as punctual as possible. If you give an appointment to a client at 4 o'clock, you must try to be there at 4 o'clock, unless your court work has kept you away from it, or you've got delayed by court work. If you say you must come at 10 o'clock in the morning, the lawyer must be ready by 10. And also, before the interview, it is always good, I believe, Mr. Jayatilak also referred to those matters. It is always good to have a knowledge of the matter that is at hand. Why is the client coming to see you? Because somebody will make an interview, will seek an interview with you, will seek an appointment. You will ask him what this matter is about. Whether it's a matter, as Sanjay said, whether it's a partition matter, whether it's a parted matter, you must know at what stage the case is, or whether it is whatever the matter is. You must make an assessment of the matter. And you must realize also to know what area of the law would be applicable. Whether it's a Public Property Act, or whether it's a Partition Act, or whether it is the Money Laundering Act, or whatever. You must also have a knowledge of what provisions of the evidence ordinance will come into play in these matters. What is the procedural law that comes into play? Whether is it the Civil Procedure Code, or is it the Criminal Procedure, the substantive law and the procedural. So in that initial interview, your first consultation, when the client discusses the facts with you, we will advise you of the facts. And you must have it in writing. As Mr. Jayatilak said, you must get it in writing. But then at the same time, what I do, my practice is I take down instructions that are given to me. And then once you have those instructions, you will be able to advise the client as to what course of action need be taken. So that will help in the building the relationship, effective, confidential relationship between litigant and lawyer. So that is something very important. The litigant must have confidence that here is, I have gone to a lady lawyer or a male lawyer who has the competence, the skill and the knowledge to handle my matter. A man, a lawyer who treats me with respect, who is courteous to me, who is punctual, who doesn't keep me waiting for 1.5 hours like most doctors do in hospitals when we go for consultations. Now, those are matters where I think we should develop those traits. Then at the same time, I think Mrs. Jatilek also made a very valid point. You must also have acknowledge the capacity of the client to pay. The capacity of the client to pay your fees. That's a very important aspect. Of course, there are other matters which we will accept pro bono. Without legal fees, we will certainly take our cases. If you make an assessment that the client has no capacity to pay, but there is a cost that you must fight for on behalf of the client, then you should also take over those matters. Not refuse, not straight away send the client away without saying, refusing, no, sorry, unless you are paying me, I cannot accept it. We all have a responsibility towards society. That is our part of our corporate social responsibility role. We also have a CSR role. CSR role will require us to engage in certain pro bono litigation. So like that. So, those are matters which will enable the building of confidence. Those are the building blocks, one may say, in the constructing the relationship between lawyer and litigant. And I'm sure others will have their own kind of comments on the matter. So those are my comments, initial comments. I mean, others can also build on that.
May I add a few comments to that? Now, generally, I think the most important thing that one should consider in these type of things is the patience. The counsel should have proper patience to listen to the grievance of the client, because sometimes the clients come and say various things, and sometimes we also, as human beings, we also lose our temper. But we should never lose our temper in dealing with the clients. We have to be very much concerned about their issue and act with proper understanding. And as the President's Council has pointed out, punctuality, then this organization of the interview, and how to prevent it from going from unnecessary avenues. Those the controlling of the proceedings, those things will have to be taken into account. But there's one other thing that I'll have to say. This is not something that can be obtained within 1 or 2 days. Now, if you have taken oaths today, you can't be one cannot expect you to have all those skills on the next date. But there are certain exceptional cases. But with your practice and with your experience of handling clients of various walks of life, you will develop that. And with the other aspects that Mr. Maddegoda has pointed out, I think we can have a good good communication skill in listening to our clients. Thank you.
So we have one more question. I would like to forward that to Mr. Koditurakku. Sir, could you briefly explain what are the remedies available for a client when an attorney at law fails to disclose his or her conflicts of interest or any other misconducts?
Yes, it's a bit of a tricky question that you have put to me, because now conflict of interest carries lot of subtopics, subheadings. Now, if you look at Justice Samarasingha's book on professional ethics, his lordship has dealt with this conflict of interest under several headings. But if I am to answer your question very briefly, if if there is conflict of interest, it is the prime responsibility of the counsel not to accept that case. Now, sometimes there can be instances where you have a long-standing client, and with the relationship that you have with the client for a period of 10 to 20 years, then you will come to know basically everything about the client, sometimes even his personal details, everything. And if some other person wants to retain you to file action against that client, the long-standing client that you had, that is not permissible. Now, in such a situation, if a client feels that you have acted contrary to the best interest of that client, and there was and by your conduct there had been conflict of interest, then of course he can even complain it to the Supreme Court. And the Supreme Court, as Mr. Maddegoda very correctly pointed out at the initial discussion, under the Judicature Act and the relevant rules, then of course the Supreme Court can direct the Bar Association to initiate an inquiry against that attorney at law, and thereafter, even based on that inquiry, there can be a rule also against that attorney at law, and there can be disciplinary steps that will be taken by the Supreme Court. So you'll have to be extremely careful when you are undertaking your clients' cases, that you should never have conflict of interest in undertaking your work. Thank you.
Just one point to that. Also, if at the initial stage you don't know there is a conflict, and over time you realize that there is a conflict that arises, at the first available opportunity, if you realize there is a conflict that arises, then at that point in time, it is your bounden duty to withdraw yourself, recuse from that case. Maybe there was no case or no conflict, but you go over time, as you realize the case goes on, you realize that there is a matter. We may have forgotten that. I mean, these things happen as you go on in years, as Sanjay said. These are not some things that you acquire, skills that you acquire overnight, over a long period of time in practice. But then you realize that there is a serious conflict in the matter, or that there is some conflict, that somebody of yours is associated with the other side or whatever. At that point in time, you must immediately advise your client and say that there is a matter like this, that you are extremely sorry, right? And that this is something you never knew at the very beginning, and it has now come to light. And for that reason, I would want to recuse myself from appearing any further in the case, or from acting for the litigant any further. And also, it will be good also if you can also advise the court at the first available opportunity that you are no longer in this matter, or the instructing attorney. If it's a civil case, the instructing attorney, or in a criminal case, the junior can say that the senior counsel is unable to continue with this case because there is a situation as that has now arisen, and for that reason, they're keeping the court apprised about his inability to appear anymore in the case.
Thank you so much, sir, for your
Further to what Mr. Maddegoda said, I would like to add, it might be to look after your best interest. I think it would be good just to write a letter to the Bar Association also, to keep the Bar Association informed of that situation.
Thank you, madam. Unfortunately, the time has come to an end, and I would like to take this opportunity to thank our panelists for taking their time today to provide us with valuable insights as to the importance of clients' interviewing process. And I would also like to thank all the participants for their actively engaging in this discussion. And last but not least, I would also like to take this opportunity to thank the BASL Professional and Career Development of Women Lawyers Committee and the BASL Seminars Committee for providing us with this invaluable opportunity to be a part of this webinar to learn from these distinguished panelists. I would now hand over this discussion to Pasiduni. Thank you. Good night.
Thank you, Chamika. On behalf of the BASL and the Professional and Career Development of Women Lawyers Committee of the BASL, I would like to thank Mr. Anura Maddegoda, President's Counsel, Ms. Nalini Jayatilaka, Attorney at Law, Mr. Sanjaya Kodituaku, Attorney at Law, and our moderator for the day, Mr. Chamika Guruge, Attorney at Law, for this very informative and valuable session. I would also like to thank all of you who joined us through Zoom and YouTube and for your questions that have made this webinar an interesting one. So thank you everyone. Join us again next week on Saturday at 7 p.m. for the 23rd episode of this webinar series on a different topic. Stay safe and good night.
Thank you. Good night.
Thank you, Pasindhani. Thank you, Chamika, and rest of our panelists, my members of the bar. Thank you very much for providing.
Thank you very much. Good night.
Thank you.
Thank you.